This is Barry Zellma on insurance. Today it's time to speak about avoiding charges of bad faith. The basic test in bad faith lawsuits is whether the insurer unreasonably and without proper cause refused to compensate the insured for a loss covered by the policy. The adjuster dealing with a claim should not attempt to adjust a claim or even contact an insured until he or she knows everything necessary to protect the rights of the insurer without doing anything to injure the right of the insured to receive the benefits of the policy. This means the adjuster must have thoroughly reviewed the wording of the insurance policy, the application for insurance, and the loss notice. The adjuster must then begin to investigate all claims fully and thoroughly. Charges of bad faith can be eliminated by adjusting all claims in a detailed and fundamentally sound manner. People insure themselves for peace of mind and security. To protect these interests, it is essential that an insurer fully inquire into the possible bases that might support the insured's claim and act promptly. The insurer may not gather just enough evidence to support a belief that the policy does not provide coverage and then quit the search. Furthermore, the adjuster must know the state's Unfair Claims Settlement Practices Act and the regulations created to enforce the act. Following the statutory guidelines can support a defense to allegations of bad faith. The adjuster should send a reservation of rights letter and formal denials of coverage to an insured as soon as possible after collecting sufficient evidence to establish that there are grounds to reserve rights, concerns about coverage, and/or grounds to deny coverage. It could be as simple as the claim was made to the wrong insurance company. The adjuster must make sure that there is a reasonable, factual, and legal basis before denying coverage. For example, the adjuster should interview the appropriate individuals to determine whether they possess any knowledge relevant to coverage, document the results of the investigation, make sure all facts relied upon in making a decision are accurate, obtain advice of legal counsel, whether defense counsel or specialist coverage counsel as appropriate, check with counsel to determine whether the policy provision relied on to deny a claim has been held valid or invalid, enforceable or unenforceable by any state or federal court. If a claim is related to an individual's health or personal injury, the adjuster must make reasonable efforts to obtain all available medical information relevant to the claim and use skilled personnel in evaluating those documents. The adjuster should carefully consider the ramifications faced by the insurer before refusing to settle a claim. If the adjuster believes a claim should be settled, the adjuster should settle the claim promptly and as soon as the adjuster is certain of the exposure and liability of the insurer, and once the adjuster has sufficient authority to effect a settlement. Where there is any concern over potential bad faith ramifications, the adjuster should have a claims supervisor analyze and oversee the management of the claim. The adjuster must be courteous at all times and truthful in all contacts with the insured and our claimants. The adjuster must be ready to conduct additional investigation when new information arises. He or she must be familiar with the policy, its conditions, warranties, exclusions, and provisions, and apply them to the direction of a complete and thorough investigation. The adjuster must determine how the applicable policy provision have been interpreted by the courts to ensure the reference materials such as claims underwriting materials and opinions from lawyers are current. The adjuster should make a complete and impartial evaluation of every claim and inform the insured of his or her rights under the policy, and the adjuster must always respond to the insured's request for clarification of those rights. If it is clear that an insurer had no liability, an action for unfair trade practices or bad faith will not go forward. In Rogers versus Unitrim, a 2005 decision, the district court held that because the insured's loss was excluded from coverage, their claim for unfair and deceptive trade practices must fail. Similarly, in other cases, the courts have held that where liability was not reasonably clear, insureds can not recover on unfair and deceptive trade practices claims. In South Carolina, although the insurer owes the insured a duty of good faith and fair dealing, that duty of good faith arising under the contract does not extend to a person who is not a party to the insurance contract. Thus, no bad faith claim can be brought against an independent adjuster or independent adjusting company, although Washington State tried to assert such a situation in a case called Qdala versus Allstate, which found an adjuster liable only to be reversed by the higher court. The adjuster should ask counsel to check recent federal and state court decisions to determine whether any of the policy provisions relied on to deny the claim have been held invalid in the state where the loss occurred. To avoid claims of bad faith conduct, the investigator must not resort to fraud, deceit, or misrepresentation to gain information from a person being investigated. The investigator or adjuster must never eavesdrop, trespass on the insured's property, shadow the insured, or participate in any other form of harassment without good cause. The adjuster should never destroy evidence supporting the insured's claim for benefits or refuse to investigate a claim because the insured has failed to fill in the entire claim form. The adjuster must never evaluate a claim only if the insured fails to use a particular form, as long as he or she provides the information required. The adjuster should never withhold pertinent information from an examining physician on an independent medical exam, or even more horribly, instruct the physician what to find. The adjuster should never ignore the state's Unfair Claim Settlement Practices Act and regulations created to enforce it, nor should the adjuster refuse to follow the statutory guidelines or deny claims or reserve rights orally, or engage in investigative and claims handling techniques that are illegal, fraudulent, intrusive, or harassing. For example, Some adjusters have been found to have acted in bad faith when they concealed or failed to disclose benefits, where the concealment of or failure to disclose coverages or other provisions that are pertinent to the claim, making intentional misrepresentations of fact or law, or intentional misrepresentations of policy provisions, refusing to pay claims without conducting a reasonable or thorough investigation, failing to promptly provide a reasonable and proper explanation on the basis for a denial of a claim, making threats of dire consequences to force the insured to agree to an unfair settlement, making false accusations or oppressive demands, like the insurer that once claimed that an insured suffered from a disease only a horse could get, exploiting an insured's vulnerable position as a person who has suffered an extreme loss, interpreting the policy in an unduly restrictive way, or failing to appropriately advise a claimant of his, her, or their rights under the law, including any relevant statute of limitations. The only way for an insurer to avoid an action being brought for statutory bad faith in Florida was set forth in Section 624.155, parentheses 2, close parentheses, parentheses D. It follows that an insurer cannot escape liability for a violation of the section by the simple expedient of a belated payment of the policy limits after the 60-day time period provided in the section expired. The belated payment by the insurer neither automatically proves nor disproves first-party bad faith. The insured must still establish that the insurer's failure to pay the policy limits by the expiration of the 60-day window period constituted bad faith as defined by the statute. The 60-day window is designed to be a cure period that will encourage payment of the underlying claim and avoid unnecessary bad faith litigation. The statutory cause of action for extra-contractual damages simply never comes into existence until expiration of that 60-day window without the payment of damages owed under the contract. A court has found that in creating the statutory remedy for bad faith actions, the legislature provided a 60-day window as a last opportunity for insurers to comply with their claim handling obligations when a good faith decision by the insurer would indicate that contractual benefits are owed. This was Talat Enterprises versus Aetna, a 2000 decision of the Florida Supreme Court. The ruling by the Supreme Court of Georgia in McCallum versus Quarles, an insurance company could always avoid a bad faith penalty and payment of attorneys by instituting a declaratory judgment action within the period of 60 days from demand on it, with little prospect of having the issue decided before the expiration of 60 days unless it subjected itself to a ruling against it on the question of bad faith. This is Reliance Insurance Company versus Brooks Lumber, a 1960 decision of the Georgia Court of Appeal. Simply stated, if an insurer wishes to avoid claims of bad faith and lawsuits seeking damages under the tort of bad faith, they need to train and educate their entire claim staff on how to read insurance policies and understand them, how to apply the conditions, provisions, limitations, and exclusions of an insurance policy to the facts of an investigation, and to be able to conduct a fair and thorough investigation of every claim assigned to the adjuster with excellence in claims handling. And this includes that the management of the insurance company must work with each claims person, evaluate their work, supervise their work, educate them if they do not have the education and training, and if they find they have a claims person who is not acting fairly, dismiss that claims person immediately. This video was adapted from my book, Selma on Insurance Claims, Part 106, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be of use to you or your colleagues, please pass it on. It's free, and please also subscribe to my Rumble channel, my YouTube channel, my blog, and my Substack publications so that you can learn about future videos and future blog postings. Please also click on the like buttons and the Rumble buttons when you view these videos to let me and the world know that you liked what you heard and learned from it. Thank you for your attention.